Babarski, who are both attorneys with Legal Aid Services of Oregon. They work in the Portland Regional Office of Legal Aid. I am a former legal aid lawyer, but now I'm in private practice. My role is that I coordinate the Legal Aid Foreclosure Help Project. So just to give you a little background on legal aid generally, Oregon has two main providers of free civil legal services. The Oregon Law Center is one of them, and the other one is Legal Aid Services of Oregon. They provide civil legal services, so not criminal law. They don't do criminal defense, but they provide free legal services in a whole bunch of different kinds of civil areas of practice: family law, civil rights, disability rights, employment, housing, public benefits, and other things that I'm not thinking of. They have offices between the two agencies that cover the whole state of Oregon. And if people want to access their services, the best way to do that is to find out what your regional office is. You can do that by going to this website, which I'll put in the chat too. It's OregonLawHelp.org. If you go there, it'll show you, which Oregon Law Center or Legal Aid Services office is your office. So you can just call and apply for service by talking to someone on the phone at your local legal aid office. Like I said, I work for the Legal Aid Foreclosure Help Project, and we provide free legal help to homeowners who are facing foreclosure, low-income homeowners who are facing foreclosure, as well as tenants who are living in homes that are at risk of foreclosure. We represent people who are under 200% of the federal poverty guidelines, which is a little bit higher than the general legal aid cutoff. And we also help people who are between 200 and 400% of the federal poverty guidelines, which is most people who live in Oregon. So if you are living in a home that's at risk of foreclosure, try giving us a call. There's a good chance that you qualify for our services, even if you don't think of yourself as low income. We have our own special intake line. It is in the Portland area, 503-227-0198. I'll also put that in the chat when I'm done talking. And we have a statewide toll-free number, which is 855-412-8828. We have intake workers who are bilingual in English and Spanish, and they can also access, I'm sure they can access TTY if they need to. And we also have access to a language line that lets them get an interpreter in any language that a caller speaks. Let me see. So we help borrowers and tenants with a whole bunch of different problems. I mean, we can help people with judicial foreclosure, with advice on non-judicial foreclosure. I should say that our project right now is scheduled to end on June 30th. So at this point, we're mostly just giving people advice over the phone and referrals. But do give us a call, even if you have a foreclosure related issue that might take longer to finish than just June 30th. We can probably connect you with resources that can help you keep your home. Some of the legal aid offices will continue to do foreclosure prevention work even after June 30th. For example, the Portland Regional Office, which serves a pretty broad geographic area, will still be able to handle some foreclosure cases even after June 30th. Yeah, I think that's all I want to say to kick it off. I think I will turn it over to David now to talk about some of the substantive protections that exist for people who are facing mortgage default right now.
Thanks, Hope. Okay, so just kicking off, my name is David Cohn. I am a staff attorney with the Legal Aid Services of Oregon Portland Regional Office. Usually I work in our office downtown at 520 Southwest 6th Avenue, Suite 700, but due to the pandemic, we are all working from home. Couple other things. The information that I'm going to talk about is current as of yesterday, and the information, as you may know, is changing rapidly in this area. So just make sure that if you're relying on any kind of information that you may hear about, just keep in mind that it may have changed by the time that you need to access it. Also, the information that I'll give is not legal advice, and if you do need legal advice, you should consult an attorney for more information about how the law applies to your specific situation, because even the smallest difference in facts can sometimes make a huge difference in how your case can be handled. Okay, so I'm going to talk a lot about a new federal law called the CARES Act, and I'm going to talk about how the CARES Act allows people sorry about that. I'm going to talk about how the CARES Act applies to most home loans, although not all, and I'll try to explain as best I can how the CARES Act applies to certain loans and how it doesn't apply to others. So the CARES Act, it basically provides foreclosure relief for federally backed mortgage loans, and that means mortgage loans for 1 to 4 family properties. And that basically means loans that are purchased, securitized, owned, insured, or guaranteed by the following government agencies: Fannie Mae or Freddie Mac, or if they're owned, insured, or guaranteed by the Federal Housing Administration, the FHA, the Department of Veterans Affairs, the VA, or the U.S. Department of Agriculture, the USDA. And when we talk about FHA loans, we're also referring to the most common type of reverse mortgage, which is called a home equity conversion mortgage. So if you have a federally backed mortgage loan under the CARES Act, if you are experiencing a financial hardship that's due directly or indirectly to the COVID-19 emergency, you can request or obtain forbearance from mortgage payments for up to 180 days. And then you can, if you need more time, you can request and obtain additional forbearance for up to another 180 days. So almost a year. So who do you request this forbearance from? You request it from a company called your loan servicer. And the loan servicer is sort of like the middleman between you and the lender, the company that actually has the right to your payments. And the loan servicer is the company that you have probably dealt with a number of times if you have a mortgage. It's the company that you get account statements from, that you send payments to, who might contact you if you haven't made payments or if you haven't kept up with your taxes or insurance, that kind of thing. And I'm going to talk in a bit more detail a bit later about what you can say to your loan servicer if you do call your loan servicer. And please note that in order to get this forbearance, it's not just going to be automatic. You actually do have to reach out and call your loan servicer. And you should be able to contact your loan servicer if it's not obvious to you by, for instance, calling a number or using a fax number or address on your monthly account statement, say. And if that's not available. I would think that you could probably find this information online for whoever your mortgage company is. Okay, so what happens during a forbearance? Basically, if you get a forbearance, you don't need to make your regular monthly payments. That doesn't mean that they're not going to be eventually due, but for the time being, you can hold off on making them, and there's going to be no fees, penalties, or interest accruing on your account beyond the amounts that are scheduled or calculated as if you had made all your payments on time and in full under the terms of your mortgage loan. And the period during which you can ask for a forbearance at this point appears to be as long as the emergency lasts, or until December 31st of this year, whichever is earlier. So regardless of whether your mortgage is federally backed, and I'm going to talk in a little bit of detail about how you might find out whether your mortgage is federally backed. Regardless, though, of whether your mortgage is federally backed, if you think you're going to have trouble making your mortgage payments, you should contact your mortgage company right away to ask what forbearance or other kind of relief options are available. Okay, so how do you determine if you have a federally backed mortgage loan? Most loans that people get, most mortgage loans that people get are guaranteed by two companies called Fannie Mae and Freddie Mac. And to determine whether your mortgage is a Fannie Mae or Freddie Mac loan, you can use the a couple of different online lookup tools, which will require you to enter some identifying data about your loan. And the one for Fannie Mae, and I can post this after I get done talking. The one for Fannie Mae is knowyouroptions.com/loan lookup. And the one for Freddie Mac is www.freddiemac.com/corporate. And again, I will put those addresses in the chat box when I'm done with this section. Okay, so what if you have a loan from the VA or the Department of Veterans Affairs, or what if you have a loan guaranteed by the VA? The mortgage, and I'll just talk about some terminology here. When I talk about mortgage, I can also be referring to something called a deed of trust. And a deed of trust is like a mortgage. This is, it's for all intents and purposes for our conversation here, it is a mortgage. And this is just the form of the kind of a mortgage-like instrument that's used in Oregon instead of a mortgage. But a VA loan will contain a clause saying this loan is not assumable without the approval of the Department of Veterans Affairs or its authorized agent. And if you still have the documents from when you closed on the loan, when you first got the loan, there's a document called the HUD-1 settlement statement, and that should include a charge for a VA funding fee. Although I should say that not all VA loans require this fee. Okay, so how do you know if you have an FHA loan? Lots of people have FHA loans. Normally, the loan will have an FHA case number at the top of the promissory note, which is basically a contract that you sign saying that you owe the lender money. And there will also be an FHA case number at the top of the trust deed. And FHA mortgages normally show a charge for, again, you can also look at the HUD-1 settlement statement that you got, if you still have it, when you closed on your loan. And FHA mortgages normally will show a charge for a mortgage insurance premium of FHA, or sometimes it's referred to as the MIP on the HUD-1 settlement statement. And the charge might also appear on your monthly statement. Now, I should say that unfortunately, some loans that went into default during the foreclosure crisis that, we kind of seems like just got out of not too long ago, they were stripped of their FHA insurance status, and borrowers were notified if this happened, but otherwise the only way to know is to ask by calling HUD's National Servicing Center at 877-622-8525. And I will try to remember to put that number in the chat box too. I should give you a strong word of warning though. My understanding is that the National Servicing Center, like a lot of things, is not very responsive at the moment. So I don't think that you should necessarily count on being able to contact someone there. But I also want to note that FHA loans include the most common type of reverse mortgage, which also is known as a home equity conversion mortgage. And they usually say home equity conversion on the promissory note and trust deed or mortgage. Now the last type of federally backed mortgage loan that I want to talk about is the USDA loan or a U.S. Department of Agriculture loan. And there will usually be some kind of indication on the HUD-1 settlement statement that you get at the closing that this is a USDA loan. There may also be a guarantee, a USDA guarantee attached to the promissory note. And the words rural development may also appear on the last page of the deed of trust. Okay, so now let's talk a little bit more specifically about the protections that you can get on federally backed mortgage loans. So the government entities that run these federally backed mortgage programs have announced a moratoria, which basically means they're not going to foreclose on loans, Fannie Mae loans, Freddie Mac, FHA, with the exception of loans for vacant or abandoned properties, VA or USDA guaranteed mortgages through June 30th of 2020. So the last day of next month. They will not be foreclosing on your home if you have one of these kinds of loans. Okay, so in addition to, let's say you get a forbearance, and again, I'm going to talk about, some specific tips for how to go about asking for a forbearance. But I should say that if you get a forbearance, each kind of loan has different repayment options. And I don't think that we have time to go through all of the different repayment options, but I'll just hit like a couple of highlights. So right now, borrowers of Fannie Mae or Freddie Mac loans who have several options to repay the forbearance amounts. And if you have a Fannie Mae or a Freddie Mac loan, you should contact your servicer to see what your options are. And I also, just a word of warning, if you're looking at your loan documents, like if you're looking at your deed of trust, sometimes you'll see at the bottom that there'll be a notation, there'll be a mention of, you'll see the words Freddie Mac or Fannie Mae maybe at the bottom of the documents. That does not necessarily mean that it's a Fannie Mae or Freddie Mac loan. Okay, so what in order to find out whether it is a Fannie Mae or Freddie Mac loan, the easiest way is to go to one of those websites to look it up. And I will go ahead and again, I will put that in the chat box at the end of this section. But so starting on July 1st of 2020, borrowers of Fannie Mae and Freddie Mac loans who regain the ability to make their payments on time, they'll be able to avoid repaying their missed payments until they sell their house, they refinance their current mortgage, or the term of their mortgage ends. Okay, so in a lot of cases, it'll just be put on the back of the mortgage loan. Now, also with Fannie Mae or Freddie Mac loans, servicers are required to reach out to borrowers in forbearance about 30 days before their initial forbearance period ends to discuss repayment options. But you can also be proactive about that if you'd like. Okay, so let's say that you think that you've been directly or indirectly affected by the COVID-19 emergency. You're thinking that you're going to be having trouble making your mortgage payments, or you can't make your mortgage payments for whatever reason. And it's how do you request a forbearance? Okay, well, you can call up the loan servicer. A lot of loan services will have fax numbers too, but I really think that it's probably best to request a forbearance from the servicer in writing in a form whose receipt you can track, like by certified mail or fax. Now, I guess a possible downside of that is that if that's the only thing you do, the servicer might not get back to you. Or it may take a long time for the servicer to get back to you. So if you do it in writing, and I would encourage you to do so, I think it would also be a good idea to follow up with the servicer by phone and say, look, I sent you a request in writing for a forbearance, and now I'm calling you to follow up. Okay, here's another tip. It may be best to think about requesting the maximum possible initial forbearance, which is 180 days. And if, my position is that if you ask for a forbearance, whether it's, 1 day or 180 days, however long it is, that's up to you. And if you request it, it's my position that the servicer is required to give it to you. And so now, let's say 180 days goes by and you're still needing forbearance. Before the forbearance period is up, it may be best to request, again, the additional maximum possible forbearance, which is another 180 days. So depending on the circumstances, you may well be entitled to up to 360 days of forbearance. And again, that doesn't necessarily mean, that you're not going to have to repay the amounts at some point. It just means that you'll be excused temporarily from making them. And depending on what kind of loan you have, the servicer may be required to give you the full amount of time that you request. And you should clarify any repayment terms that you come to an understanding with the servicer about. And if you get a forbearance by phone, ask for the confirmation in writing of the terms of the forbearance and the repayment. You may not always get that, but I think it's a good idea to ask for it. And if you, particularly if you don't get it in writing, I think it makes sense to write to the servicer, put something in writing to the loan servicer saying, this is my understanding of the forbearance, the terms of the forbearance. And if you do talk to the loan servicer by phone, I would recommend that you keep careful notes of that, including the date and time of your call, the name and position and department of the person that you speak with, and also what you said and what the representative of the servicer said. So at this point, I think that I am going to hand it back over to Hope briefly to talk more about some important points of dealing with your loan servicer.
Thanks, David. I just have a couple things to add. I wanted to talk a little bit about the Consumer Financial Protection Bureau mortgage servicing rules. So the Consumer Financial Protection Bureau, or I'll sometimes just call it the CFPB to be shorter, is a federal agency that was created about 10 years ago as part of the Dodd-Frank package of laws that helped fix the economy in the wake of the mortgage crisis that happened 10 years ago. The CFPB is charged with regulating mortgage lenders and mortgage servicers and other financial services companies that we all deal with. The CFPB has issued rules that govern how your mortgage servicer needs to deal with you if you get behind on your loan. And if you're applying for a loan modification or some other kind of assistance to try to keep your house. And it's the rules are very broad. They cover a lot of different things. I'm just going to talk about a couple of highlights that might help you if you're getting behind because of the COVID-19 emergency. One is that the CFPB rules require your lender to reach out to you if you get behind. It used to be that if you got behind before these rules were in place, you were kind of on your own. You just had to make sure that you were proactive and making contact. But the CFPB rules make it so that your lender has a duty to try to help you. They also have to appoint somebody on their staff to be a single point of contact for you, somebody that you can reach out to, an identifiable person who is your person to help with your loan. Another thing that the CFPB rules do that's helpful is that they prevent your mortgage servicer from starting a foreclosure until you're at least 4 months behind. So, like David said, if you get behind, the earlier you can reach out and try to get help from your lender, your servicer, the better. But you should also, know that you do have some time. They can't start, in general, mortgage servicers can't start a foreclosure because you're just 30 days behind. As long as your loan is a federal loan, federally related loan, they're going to have to wait at least 4 months before they start taking action to take your house away from you. So, the takeaway, I think, is it's urgent if you get behind, but it's not such an emergency that you should panic. You should just start the process of working with your lender right away. I also wanted to talk about a couple of Oregon-specific programs. The first one, it actually just closed up. It was called the Oregon Homeownership Stabilization Initiative. And it was a program that gave borrowers who are at risk of foreclosure assistance to fix their defaults. They actually had cash that they would give people to help pay their mortgages, to pay their property taxes, to get them back on track. And then that money would become a forgivable loan. If you've stayed in your house for 5 years after getting this money, the loan would just go away. It was a really great program. So like I said, it just closed up about a month ago, but there is some chance that OHSI will restart again. So I think it's a good idea if you think you might be eligible for that kind of help to monitor OHSI. If you go to their website, and I'll put this in the chat too, you can sign up to get email updates from them so that if the OHSI program comes back, you can get an email telling you that it's back online. So that's one thing. Another helpful program we have here in Oregon is the Oregon Property Tax Deferral Program. It's for senior citizens who are over 62 and people who are disabled, who qualify for disability, and are low income. As long as you have lived in your house for the right amount of time and you meet the age or disability and income requirements, you can qualify for the state to pay your property taxes for you. And then that money that the state uses to pay your property taxes also becomes kind of like a soft second, like a lien against your house that you don't have to pay until sometime later. Usually after you sell the house, or if the homeowner dies, or they aren't using it as their their principal residence anymore. But it's a really great program because it, reduces the amount of money that people have to pay going out monthly by the amount that would otherwise go to their property taxes. Usually the application to be accepted for the property tax deferral program has to be filed by April 15th every year. But this year, because of the COVID-19 emergency, they have postponed their deadline to June 15th. And I sent the application in to Don't Shoot PDX. They should have it. If people want access to it, they can probably email it. You can also find it on the Oregon Department of Revenue's website. So if you think you might be eligible for the property tax deferral, and if that would be helpful to you, I really encourage you to apply for that. I think that's it. And I think next we're going to hear from Rebecca about a number of different topics that she's going to talk to us about.
Oh, I'm sorry, Hope. I just wanted to add a couple of brief things, and then I'll turn it over to Rebecca. Just following up on the forbearance stuff. Let's say you get a forbearance, but or let's say you're thinking about asking for a forbearance, but you're a little hesitant to do it because you're worried, oh, well, how is this going to affect my credit? Is this going to put a dent in my credit? Well, the CARES Act has an answer for that. It put a new credit reporting rule into effect concerning forbearances. So if you get a forbearance because you were affected by COVID-19 during the period starting January 31st, 2020 until the later of July 25th, 2020, or 120 days after the end of the National State of Emergency Declaration, the servicer has to report the account as current to the credit reporting agencies if you were not already delinquent, okay? And I also briefly want to talk about some general resources, and I will post links to these, which I think are really good for some general information. So there's an organization called the National Consumer Law Center, and it's during the COVID-19 emergency, it's making available to the public for free the digital version of its most popular publication. It's called Surviving Debt, and I'll post the link to that. And Surviving Debt is for consumers, and it explains the steps that families, if your family's in financial distress, it explains the steps that you can take concerning all kinds of different consumer issues: foreclosures, repossessions of cars, utility terminations, landlord evictions, debt collection, medical debt, student loans, credit reporting, credit cards, criminal justice debt, and other topics of special current interest. The other link I'll put up there is a list. This is also from the National Consumer Law Center, NCLC. It's called Major Consumer Protections in Response to COVID-19. Now, just a word of caution that the information in these publications tends to be a bit general, and it may not be one size fits all, and there may also be specific Oregon protections that these links don't cover in detail, or maybe not at all, that you might want to contact an Oregon lawyer about, just to be sure that you're on the right page when it comes to that kind of information. Okay. And the last thing I want to talk about is on a little bit of a different subject, on the garnishment and bank offsets of stimulus funds. With any luck, you have gotten your stimulus payment, and with any luck, you don't have overdraft fees or a negative balance in your bank account to worry about. But I'll say that on April 18th, so just about a month ago, Governor Kate Brown issued Oregon Executive Order 20-18. And with some exceptions, it prevents judgment creditors from garnishing your stimulus funds. So if you have a judgment against you, like from a credit card or something like that, the judgment creditor cannot garnish your stimulus funds. But with a couple of exceptions. The exceptions are, the first exception is for a judgment in a criminal action that requires you to pay restitution. The second exception is for a civil judgment if you've been convicted of a criminal offense, but provided that the civil judgment is based on the same underlying facts as the conviction. So that's garnishment. There's another issue with respect to bank offsets of stimulus funds. So let's say you have a negative balance in your bank account, or you're assessed with overdraft or other fees. The financial institution that you bank with, the bank or the credit union, may be able to satisfy that obligation from the stimulus funds. Now, the big four banks, which almost have about almost half the deposits in the U.S., and those are J.P. Morgan Chase, Chase Bank, Bank of America, Wells Fargo, and Citi. They have said that they will refrain from taking overdraft and other fees from the stimulus funds, although at least in the case of Wells Fargo and Citi, the forbearance is going to be only temporary. And my suggestion would be that if you, the surer you can be about making sure that your financial institution isn't clawing back any of that stimulus money for fees and so forth, you know, it may be best to make sure that the creditor does not have the ability to do that after, you know, to the extent that the creditor is, or the bank doesn't have access to it. So, you know, it may make sense to, you know, spend that money. For instance.
This is the interpreter. Would you mind clarifying that last piece of information? I'm a little bit lost in what you're talking about with all of the things. Just that last little bit of info could be clarified.
Oh, yeah.
Appreciate
Okay.
it.
Yeah, sorry about that.
Okay. Okay. Moving very fast. There's a lot going on.
Sure. Okay. So if stimulus funds have been deposited into your account, you should assume that, and you have overdraft fees, say, you should not assume that the bank is going to hold off forever, if it's even going to hold off at all, from taking those stimulus funds for like overdraft fees. So just assume that the forbearance of these financial institutions is going to be only temporary at best. And now, let's say that your financial institution, let's say you've gotten your stimulus funds, right? And let's say that your financial institution has already taken amounts out of your stimulus funds. My recommendation would be call up your bank and suggest that your bank or your credit union refund the money. There shouldn't be too much harm in doing that. And at least anecdotally, I think people who have bank accounts where this kind of thing has happened have had some success in getting banks to return those funds. So that's what I have to say. And I will now hand it over to my colleague at Legal Aid Services of Oregon, Rebecca Babarski.
Thanks, David. Hi, my name is Rebecca Babarski. I'm an attorney. I work with David in the Portland Regional Office of Legal Aid Services of Oregon. I'm going to be talking about both student loans and unemployment insurance benefits. So I'm going to start with unemployment because I know that's something that is pretty urgent and on a lot of people's minds right now. Like David and Hope, I'm not going to be giving any legal advice today. Everything I talk about is going to be general information that's not particular to any one person's situation. But I do want everyone to be aware that we have a public benefits hotline. It's a statewide hotline for legal aid. Due to all the things that have been going on recently, we have extended hours. So generally now that hotline is available Monday through Friday from 9 a.m. to 12 p.m. and then again from 1 p.m. to 4 p.m. And I'm going to try to send that information out right now in the chat on the side. And so if you call the hotline, it's staffed generally by an attorney, and we will try to give you, brief information, advice, if that's sufficient for the question that you have. If there's something more that we can do to help, for example, if you are having an unemployment insurance hearing on a denied claim and you're seeking representation, we can't guarantee that we could help you. We might just be able to give you some advice for proceeding with that hearing. But in certain situations, we might be able to offer representation. Then we'll refer you to the local office from the hotline and determine if we can help you with your case. So I would strongly encourage anybody to call the hotline if they have questions about unemployment or other government benefits. And yeah, we're also going to be answering questions on the hotline about applications for unemployment insurance benefits, because we know, people do have questions as they're filling out these forms online. So I'm just going to open my notes here. Okay, so one thing that I'm sure that people are very worried about is the delays that they're experiencing in the processing of applications and things like that. So that's not something, unfortunately, that I can offer relief for right now. There is a really good article in the Oregonian from May 13th that's available online called Oregon's Unemployment Benefits Fiasco, Where Things Went Wrong and Where They're Headed. So, if you're curious about why there are delays and what to expect with those delays, I direct you to that article. Just really briefly, I think the system has just been overloaded. There was low staffing at the department, and they're just struggling to catch up with claims. It doesn't seem like there's an issue of any fear of running out of funds to fund people's claims. They're just working on a backlog. So that's why people are not able to get in touch with people at the employment department on the phone. That's why there's a backlog in claims. So for now, what we're generally directing people to do is to just make sure that you file, make sure that you keep filing your weekly certification every week with your weekly claim after your initial claim. And that's all that you really can do at this point in light of those delays. So just general overview of unemployment insurance. It's a cooperative state and federal program. It's meant for people who have become unemployed, who were previously employed, but have become unemployed by no fault of their own. So to qualify, you have to be unemployed, and that is defined as not working for pay or performing less than full-time work and earning less than the weekly benefit amount. So what your weekly benefit amount would be. And you have to be available and actively seeking full-time work. So these qualifications are important because in light of COVID-19, there's been a little modification of these to make it easier for people to qualify. So after I lay this out, we're gonna go into what those are. But technically to be eligible for UI, you need to be available and actively seeking full-time work. And you have to have earned either a minimum of $1,000 of wages in your base year, and your total base year wages have to be 1.5 times the wages paid in the highest calendar quarter of the base year. So all this is really confusing. Basically, the way that they calculate this base year, they divide the calendar year into quarters. So 3 months: January, February, March, April, May, June, July, August, September, October, November, December. So those are the 4 quarters. You look back, you decide what quarter you're in, you look back to the quarter before that, and you look back again to the previous four quarters, and that is your base year. So they're looking for 1,000 wages, and that your total wages are going to be at least 1.5 times that last quarter, or excuse me, that base year. Or you can also qualify by the number of hours worked. So they're looking to see if you have 500 hours of work in the base year and you were paid something for it. So not volunteer work, if you receive some remuneration for that, for those hours worked, for those 500 hours worked in that base year, and you're no longer employed, that is a way to become eligible. So a lot of kinds of employment are exempt from UI, traditionally like gig workers, people who are self-employed or independent contractors. There are some other statutory exemptions, like some agricultural labor and work and job training programs sometimes isn't considered eligible for unemployment. When you do qualify for unemployment, there are limitations on the amount that you can receive, and there's a certain way that your benefit is calculated. So the minimum benefit is, let's see, $141 per week for regular unemployment, and the max is $604. And you're limited to usually you're limited to 26 weeks of benefits. And the way that they determine where you fall within that range of 141 to 604, they are going to look at your base year earnings. So that base year that they look at to determine if you're eligible, first of all, and they look at what you earned in that time period and multiply it by 0.0125 to give 1.25%. So that's basically, I think it comes out to about 65% of what you were earning, but then that's capped at the maximum benefit of $604 per week. And I know this base year stuff, it's pretty confusing. There is a handbook guide on the Employment Department website that has a handy little chart that you can use to calculate and figure out what your base year is. So that's something that I refer to when I need to. So that's kind of an overview of regular unemployment insurance. And because of COVID-19, David talked about the CARES Act and different federal stimulus measures that the federal government has taken to help people in this time. So as part of that, there have been some modifications and expansions of traditional unemployment insurance that are temporary. And there have also been some traditional UI, traditional unemployment insurance, there's been kind of a relaxation of the rules. So we're going to discuss new programs that provide people with extra benefits, extension of benefits, and we're going to talk about changes to the UI rules where somebody for regular traditional UI who might otherwise not qualify will qualify for that traditional benefit due to COVID-19. So one big expansion an addition to traditional unemployment insurance, is a new benefit called pandemic unemployment assistance. So this is a new benefit that's meant for people who are out of work due to COVID-19 and are not eligible for any other unemployment insurance benefits. So, for example, if you're not eligible for traditional unemployment, this might apply to contract workers, people who have lost income because they're self-employed and COVID-19 interrupted their business, people who didn't make enough money in that base year to qualify for unemployment insurance, people who were, just about to start a job and that job was canceled due to COVID-19. And also one thing that we've run into, people who would be eligible for unemployment, but they may have had an overpayment and maybe gave some false information to the employment department in the past. And as a punishment, they have penalty weeks where they're not eligible for unemployment. So because they're not eligible for traditional unemployment because of those penalty weeks, and if they've lost their job due to COVID-19 or their source of income, they could be eligible for PUA, for pandemic unemployment assistance. So the benefit amount for pandemic unemployment assistance, the minimum is higher than traditional unemployment. The minimum for a PUA benefit is $205 per week. And the maximum benefit is $648 per week. So it's calculated, your benefit is calculated the same way as traditional unemployment. It's 1.25% of your total base year. And the good thing about this benefit, for people who are self-employed, for people who are gig workers, and especially that, this is an emergency situation. They don't want people, scrambling to get paperwork together to get immediate relief. So they're allowing people to self-certify their earnings, the money that they earned that they're using to calculate what their benefit would be, without having to provide documentation to get the minimum benefit of $205 per week. Now, if you want it to get, in addition to the $205 per week, you want it to show, hey, I earned more money, I'm entitled to a higher benefit, then you're going to have to supply some documentation. Another important thing to keep in mind is that, they are allowing people to self-certify. Basically, I'm promising that this is what the income that I had, this is the correct information, but you want to keep in mind that you could be subject to an audit in the future. The employment department could come back and say, hey, we want to check up on you. Can you prove that what you put in this application is correct? And if you can't do that, you could be in trouble. You could be saddled with an overpayment where you have to pay those benefit back, and other penalties. So, you want to make sure that you're telling the truth. Obviously, when you file this application, and try to get your documentation ready and keep it handy. And I probably should have specified this at first if I didn't already, but PUA, it's a separate benefit from unemployment. There are two separate applications for regular unemployment insurance and regular PUA. So we have been advising people, if they're not sure which one they qualify for. Of course, you can call the public benefits hotline, and we can take a look at the situation and see and offer you some advice. But it may very well be a good idea to submit both applications, because time is of the essence. PUA has a limited lifespan, which we'll get into in a little bit. It's not a permanent benefit. So if you do qualify, you want to make sure that you get that benefit in, or that application in, excuse me, sooner than later. So, Another benefit, in addition to PUA, is federal pandemic unemployment compensation. Okay, so this is that extra $600 that everybody is talking about, that comes out as part of the COVID-19 stimulus. So this is an extra $600 benefit. You don't have to submit a separate application for this benefit. If you've submitted an application for regular UI, if you submitted an application for PUA, you are going to be considered for this benefit, and you should receive a separate check if you're found eligible. So that'll be submitted to you in a separate payment from your regular benefit. This additional benefit, the federal pandemic unemployment compensation, the $600, it is available from March 29th through July 25th, 2020. So this doesn't mean that you're automatically going to receive it. They're going to determine your eligibility on a weekly basis as you continue to file your claim every week. So let's see, going back to pandemic unemployment assistance, this is the benefit for gig workers and for people that don't otherwise qualify for regular UI. These benefits can last up to 39 weeks, as long as you're eligible and out of work due to COVID-19. And the possible eligible weeks for those 39 weeks, starting in February 2nd, 2020, through the week of December 26th, 2020. So that's the time frame in which you can get pandemic unemployment assistance. So let's see. So I want to talk about, we talked about how you could be eligible for this benefit if you are out of work for reasons related to COVID-19. So by out of work, what they mean is if you quit, if you had your hours reduced, or if you were fired for reasons related to COVID-19. So there's actually a new rule that defines what that is. And I'm just gonna go through that quickly so you can have an idea of what they're looking for. So they're looking for if somebody is unable to work because they were ill with coronavirus, if you are unable to work because you have potentially been exposed to the virus and you've been subject to mandatory quarantine by your doctor or by a public health authority. If a person is unable to work because their employer has ceased or curtailed operations due to novel coronavirus, including closures based on the governor's directive or the directive of public health officials. This also includes if a person is unable to work because they have to stay home to care for a sick family member. So if somebody in your family has COVID-19 and you're staying home to care for them, that would be a reason that you're not working due to COVID-19 that would potentially qualify you for PUA. Let's see, if you have to stay home to care for a child because schools are closed and daycares are not open due to COVID-19, that's related to COVID-19, and that's considered a reason for being out of work due to COVID-19 by the unemployment department. Let's see, if your employer is asking you to work in violation of the governor's order, so say, we hear about these businesses who they're not considered essential and their owners are pushing them to be open in violation of local rules and the emergency. If going back to work was going to violate the governor's order, then you would still be eligible for unemployment or for this benefit because that's a COVID-related reason. You would not have to go to work in violation of the governor's order. Okay. So I want to talk about regular UI. And for people who qualify for regular UI, there are some things to keep in mind when you're doing your application that might not necessarily be intuitive. And, you know, hopefully we can give you an idea of how the rules have been modified a little bit, you know, relaxed a little bit to allow for these COVID-19 related situations. So we talked about regular unemployment benefits and how you have to show that you are able to work. So under the modifications to the rules for COVID-19, you are still able to work even if you're under quarantine, but you're not sick, right? So this isn't just because, oh, you decided you wanted to stay home and quarantine yourself. You have to be able to show that a health provider or a public health official, told you to stay home. You are still considered able to work if you're sick with symptoms and you haven't turned down work because you are sick and showing symptoms. So this is important because if you're turning down work because you're sick, you're not eligible, right? So if you have offers of work and you're turning them down because you're sick, you're not eligible for traditional UI, but you would then apply for PUA, Pandemic Unemployment Assistance, this special benefit that's in addition to unemployment insurance. But you wouldn't be eligible for regular UI. So for regular unemployment insurance or UI, you have to be available to work. So you're still considered available to work, even if you're under quarantine and you're not sick, but you're under quarantine. You're home to care for children due to a school closure, or you're caring for a family member due to COVID-19. So I think this is something that could trip people up on an application. If you are eligible for regular UI and you're doing that application, you know, you might hit a question about your availability to work and say, hey, I'm not available. I have to stay home and care for my kids. But you still want to indicate that you're available to work, because under the current rules, they're allowing, you know, people who are staying home to care for their kids or people who are quarantined to be considered available to work. So that other requirement that you must be actively looking for work, there's some relaxation there as well. If you are temporarily laid off, you don't need to look for another job. They just want you to stay in contact with your with that employer for when they give you the okay to come back to work. If you're not in contact with your employer, you're actively seeking work as long as you're doing what you can to be prepared to return to work or to find new employment. And generally, as long as you can assert that, you know, once this thing is over, I'm ready to go back to work and I'm willing to go back to work. I just can't, you know, leave things, you know, I can't go out for job interviews right now or whatever. As long as you can certify that when this thing is over, you're going to go out and look for a job, you know, generally that's okay. There is a little bit of mixed guidance. Like I've seen some of their guidance where they've advised people to keep like a log or like, you know, just a notebook with notes about their job search and looking for work. So, you know, if you are making efforts to do that, I would try to keep a record of what you're doing. But, you know, the rule that has been amended says that as long as you are, you know, certifying that you will go back as soon as you can start looking for a job again, that you will be okay. Okay. So there is additionally an extension for regular unemployment insurance, and this is also a separate benefit. Okay, so this is when your regular unemployment insurance runs out, which is after 26 weeks. you are then eligible, you should be eligible for federal pandemic unemployment compensation. So this is an additional 13-week extension of regular unemployment. And this is important too, because, you know, you could think, well, when my regular unemployment insurance runs out, I'll just apply for pandemic unemployment assistance because I'm still out of a job, I'm out of work due to coronavirus, and now I'm no longer eligible for unemployment insurance. But you need to exhaust this extension first. So you need to apply for this other benefit. And you're not, it's my understanding that you're not going to automatically be enrolled in it. You need to submit an additional application once your regular unemployment insurance runs out. The department's guidance says that they are going to notify people when they're at the end of their eligibility. Hey, you know, you're at the end of your eligibility, you're going to need to apply for this other benefit. Once that benefit runs out, you would theoretically then be eligible for pandemic unemployment assistance. Okay. So I think that's about it, and I'll try to entertain any questions when it's time for questions about this that I can. But I just want everybody to keep in mind, you know, things are changing really quickly. You know, things could be, the application process could be different tomorrow. And we're just trying to keep on top of things. So a lot of our interpretations of this, they're subject to change as new guidance comes out.
Hey, Rebecca.
Yeah.
Sorry, I'm going to stop you real quick. Andrew, our ASL interpreter, is going to switch off with Carly. And I just want to give them a good space to...
Oh, sure.
Okay, awesome. And thank you so much. This has been really informative. Thank you for...
Oh, good.
Yeah. All right, and let me make sure that Carly can get on. All right, awesome.
Okay, so I'll finish up on unemployment insurance just by going back to referring you all to the public benefits hotline. You can also check Oregon Law Help for updated resources on public benefits and related issues. So I can jump into student loans right now, if that's okay with everybody.
I think that's great.
Yes.
Okay. So I'll switch up my notes. So I'm excited to talk about student loans. I think this is a really, you know, it's a really big issue. It's an important area of the law for people to learn about, people to feel empowered and know about the options that are out there for them. The first thing I'll talk about, because it's immediately relevant, is the changes to federal student loans, the temporary changes that have come about as a result of the CARES Act. So this is the same law that David talked about, that Hope talked about, that, you know, has modified some things having to do with federally backed mortgages. That same law has done things to modify federal loans and provide people with some temporary relief while so many of us are struggling due to COVID-19. So the CARES Act protections for federal student loans, they apply to not all federal loans, but to loans that are held by the federal government. So if you want, and this is actually, there might be other reasons, so we'll get into this a little bit later, but there are several reasons why you might want to find out facts about the loans you have, like what specific types of federal loans you might have, because you could be eligible for different relief depending on the kinds of loans you have. So you can either, sometimes the best way to figure this out is to just call your servicer. Sometimes they will be cooperative and helpful and give you information on this, but we can't always count on servicers to do that. So the best way for federal student loans to tell you know, if you have a federal student loan, or if to tell if it's not a federal student loan, it's not going to show up on the system, is to sign into the federal student loan or the national student loan database, I think it's called, with an FSA ID. So you probably created an account for this when, like, if you took out a federal loan, you have to complete your FAFSA or whatever. And I'm just sending a link to where, with some information on how you can do this. So like with anything, with the password these days, if you forget your username, you forget your password, there's ways on the website to determine, you know, to make a new password, figure out what your username is. And if you don't have one, you can create an account. So I just sent a link to that. And let's see. So, okay. So the CARES Act has stopped garnishment for federal student loans. So, you know, when you've defaulted on a federal loan, the government can, they don't even necessarily need to sue you. They have extraordinary collection powers. So once you default, they have the power to just go in and start garnishing your paycheck, to take, you know, if you're receiving certain Social Security benefits, they can garnish those. If you are receiving a tax refund, they can go ahead and capture that if you are in default and your loan is in collection. However, due to COVID-19, the CARES Act has put in some protections that temporarily freeze those collections until September 30th, 2020. So anything that has already been garnished, so like this law went into effect, but it backdates a little bit. So if you already had funds garnished after March 13th, 2020, those are supposed to be returned to you. One thing to keep in mind, this is a recent development, but it's come to the attention of the National Consumer Law Center and other groups that several people's bank accounts, wages were still being garnished by the Department of Ed and its servicers in violation of the CARES Act after March 13th. So, you know, if this is happening to you, you can give legal aid a call to see if we could provide you some advice on your particular situation. But you should also, just in general, people should be aware that there is a lawsuit that was recently filed by the National Consumer Law Center and some other advocacy groups against the Department of Ed to try to stop these garnishments. So they're seeking declaratory relief and an injunction that would stop the Department of Ed from these garnishments and would require them to give that money back to the people that it's been taken from. The other way that the CARES Act impacts student loans right now, or federal student loans at least, so no payments are due from September 30th, or until September 30th of this year. Additionally, no new interest should be accruing on federal student loans that are held by the government until that date. So you shouldn't be accruing any interest if you have those federal student loans, and you shouldn't be having to make any payments. Everybody who's in this boat should have gotten a letter from their servicer explaining this. So you may have gotten a letter in the mail saying, hey, we're not going to be sending you any billing statements for the next few months. I believe you can opt out and say, hey, I want to still make payments, but everybody is automatically going to be put into forbearance or has been put in forbearance who would fall into this category. So let's see. Another issue that's come up with this is administrative forbearance And, it's not due to any fault of the borrower. It's not being put on people's accounts because they were late making payments or because they did anything wrong. So you would think it wouldn't negatively impact your credit, and it shouldn't. However, one student loan servicer that services federal student loans named Great Lakes, attorneys around the country have been reporting some issues with Great Lakes, and that they have been reporting this administrative forbearance in a way that they shouldn't, that has been resulting in people's credit scores going down. So this is an issue. It's not what's supposed to be happening. And I personally can say, when I read about this, I checked my credit report, even though Great Lakes wasn't my servicer, because I really just don't trust student loan servicers as a whole. And I was okay, but I would just generally, people should know that you can check your credit report. Due to COVID-19, you're allowed, it used to be that you got one report from each of the 3 agencies for free every year. At least temporarily, now you can check your credit report every week. And so the handout that we shared about general consumer issues, that includes a link to the Federal Trade Commission's website. They have a really good page that talks about how you could check your credit report with each of the 3 credit agencies for free, links to do that, and what you should do if you find bad information on your credit report that isn't accurate or is misleading, or there are things that you would want to dispute, how you can go about disputing that. So just because this has been flagged as an issue, just remind people and urge them to check their credit report if they think it might apply to them, especially if your servicer is Great Lakes. Let's see. So we talked about how tax refunds, they're not supposed to be garnished at this time, just like wages aren't supposed to be garnished at this time for federal student loans. Some people are on top of things and they filed early and they found that their refunds were garnished before this law went into effect. So this isn't set in stone by the law. It's not in the CARES Act, but the Department of Ed and their servicers have been telling people that if somebody's tax refund was taken, up until, back until March 5th, that they would be returning that, and that they would be returning it in the form of a check that would be issued by the servicer. So they have been advising people to just make sure that their servicer for the student loan has the correct mailing address for the borrower to ensure that that check can get to the borrower as soon as possible. Otherwise, there might be some delays if they don't have the correct address on file. So the unfortunate thing about the CARES Act is that it really doesn't provide much relief for people who have private loans. You can always call your student loan servicer for private loans and ask them if they can help you out, explain your situation. They may be able to offer you forbearance, a little bit of a break, or modify your payment plan, but it's just unfortunate there are no guarantees there. All you can really do is ask and see if they'll work with you. So that is basically a summary of the special issues and changes to federal student loans that have come about as a result of the CARES Act. I want to spend, I don't want to take too much more time, but I want to really briefly summarize, just in general, some of the other relief that is available for student loan borrowers, just to give a general roadmap and an idea of the things that are out there, because I think people don't always know what their options are. And even if you have some general information, hey, that might apply to me. you can give us a call. You can give legal aid a call. We're trying to do these cases and take a look at the issues people are having and seeing if we can help. So I'd encourage you to call if you think you might fall into any of these categories. Okay. So for federal student loans, there are some instances where you might be able to have your debt discharged or forgiven. So, there have been a lot of issues in recent years with for-profit schools. A lot of for-profit schools have committed, flat out fraud, promising people degrees that would help them get jobs where, that's not the case. Promising people great educations at what turns out to be a really high price, where the quality of the education they get isn't really very good at all. And people are saddled with a lot of student loan debt, and in return, they haven't gotten much of anything but a whole pile of debt. So there are some ways in those situations in particular where people may be able to get some relief, and some other scenarios not related to school fraud and school malfeasance as well. So one of these rules, and I should clarify that these apply to federal student loans. And you also have to be careful, there's different kinds of federal loans. So some of these relief, they would only apply to certain loans and not others. So that's something to keep in mind. But the first relief that we could talk about is borrower defense to repayment. So this, just really quickly, is this applies in a scenario where a school lied to a student about their program, about their career prospects, and the person then went out and took out loans and found themselves with a degree that really wasn't what they thought it was going to be. I should say that, there's a backlog of these applications. There's litigation on this, and a recent class action settlement that is supposed to help clear a lot of those backlogged applications. And the Department of Ed recently made some changes to the rules that make it a little bit harder to get relief under the borrower defense rule. But if you took out a loan before 2019, those new rules won't apply to you. So that's a good thing to keep in mind. And another good thing about this is that collection should stop on your loans when your application is received and while it's pending. So that's another good thing about the process. And if you think that this is something that might apply to you, you can call us and we could potentially take a look at it if you're eligible for our services, and see if we can assist you with that. And another thing to keep in mind, there are some bad actors, like really bad companies who, have been involved in basically scamming people for a while. And for some of these situations with particular schools, there are more streamlined processes where the Department of Ed has looked at it and said, yeah, we know like this school committed fraud. We're going to treat these applications in a different way. In other situations, there's been class action settlements that have created new processes or created an automatic discharge, like if you even went to one of these schools. So these schools where there might be different processes. So if you've gone to one of these schools and you still have a federal loan and you're still paying on it, or if it's in default, I would encourage you to call us to see if there might be, a way out of it through borrower defense. So some schools that come to mind are the Corinthian colleges, Heald colleges, Everest colleges, Wyotech, and the American Career Institute. So those are just a few of the big offenders. But if you've gone to a school and you think that they gave you bad information where you wouldn't have gone there, if you knew otherwise, you should give us a call and see if we can take a look at it. Another way, another route to relief for federal student loan borrowers is false certification discharge. So this is a scenario where maybe you find out that your school basically lied about you in some way to the federal government so that you would be eligible to get federal loans. The example that comes to mind, something that some schools have done in the past, is lie to the federal government about whether or not somebody has a high school diploma or a GED, because maybe that's a requirement for the program, and they lie to the federal government about whether or not the person has that degree or that qualification in order to get that federal student loan money. So that's basically fraud, and somebody who was the subject of that could be eligible to have their student loan discharged. Let's see. Another issue that comes up is when a school closes before you can get a degree, or if a school closes and you're not able to transfer your credits to another school to complete your degree. For people with certain federal loans who find themselves in that situation, they may be able to get their loans discharged through a closed school discharge. So that's just one more scenario where you may be able to find relief from your federal loans. Another way that your loans could be discharged, your federal loans, is a total and permanent disability discharge. So this is for people who really can't work anymore. They're not able to earn money to pay back their student loans, their federal student loans, due to a disability. So they may qualify for that type of discharge. You generally need to get documentation from your doctor showing that your condition is going to continue, that it's expected to continue for at least 5 years. So, and these are administrative applications where you submit an application to the Department of Education that makes a decision about whether or not to discharge your loan. So of course, I think most people have heard of student loan forgiveness, public service loan forgiveness. If you work for certain qualifying nonprofits, certain loans can be discharged after 120 qualifying payments. So a qualifying payment has to be in the correct payment plan. Should mention that for the CARES Act protections that we talked about earlier, these months where people aren't making payment because their loans are in administrative forbearance due to COVID-19, those $0 non-payments should also count towards public student loan forgiveness if anybody is working towards that and getting their loans forgiven in that way. So this period of non-payment shouldn't hold you back on getting your loans forgiven. There are other loan forgiveness options that I won't get into too much. There's a program for teachers to have their loans forgiven. I think it's generally if they're working in, for a low-income school, and certain other factors apply. And there's also another program for loan forgiveness tied to Perkins loans. So that's a particular kind of federal loan. For people who are having trouble making payments, you should talk to your servicer about going into a payment plan that would be based on your income. For those kinds of payment plans, you do need to certify your income and make sure that you submit a certain paperwork every year. But that's a great way to get your payment lowered. I know, for federal loans, nobody's really in that boat right now because we're not making payments. But once September rolls around, if you were having problems before, you might want to look into applying for one of these programs with the assistance of your servicer. Contact your servicer and say that your income is low and you want to change your payment plan.
Hey, Rebecca.
Yeah.
I think we are going to switch again between Carly and Andrew.
Oh, sure.
All right. Thank you. I wanted to hop in there.
Thank you for that. Go ahead.
Okay. So we talked about payment plans. Let's see. Two more things I want to talk about. If your loans are in default, so if you're already past due, you're in default, and worried about being garnished, and worried about the federal government coming after you for your balance, there are ways to get out of default. The two main ways are consolidating your loans. So you may be eligible to consolidate your loans. There are some factors that need to be considered, like the type of your loan and whether you consolidated before. But when you consolidate, you're automatically out of default and you just owe on that new loan. And another way that you can get out of default is by rehabilitation. So you can go into a repayment plan, let's see, and as long as you go into your repayment plan, maybe it's a income contingent repayment plan, and you make 9 payments for 9 months, you're on time with those payments. That is a way for you to get out of default. So that's also something that you could talk to your servicer about. If you run into issues or you're confused about whether you qualify for that, or your servicer is not being helpful with that, you can call legal aid and we can take a look and see if there's something that we can do to help. Let's see. The last thing that I want to talk about are the last two things. Bankruptcy really is an option for people with student loans, and that's part of the reason why I think all these other things we're talking about are so important, because bankruptcy is usually the way out for people who find themselves unable to pay their debts and underwater, and student loans aren't automatically discharged in bankruptcy like a lot of other debt. But it is important to know that you can discharge student loans in bankruptcy. It's just a little bit more difficult and requires kind of an extra process within the bankruptcy. So just to keep that in mind. And you also have to meet certain qualifications. So that's something that, a bankruptcy attorney could speak with you about. And the last thing that I want to mention is that for private student loans, we talked about how there's not necessarily a lot of options for private student loans, like all these ways that you could potentially get your student loan debt discharged by the Department of Ed. If you have federal student loan debt, those options aren't available for private student loans. So when people go into default and they find themselves sued, there are some companies that bring lawsuits for private student loan debt that's been defaulted on, where an attorney might be able to raise defenses to those lawsuits. So I'll leave you with 2 of those companies. One, it's not really a company, it's a number of trusts. These are the National Collegiate Student Loan Trusts, abbreviated sometimes NCSLT, with a number. So they're like 15 of them, I think. They file a lot of lawsuits for people who took out private loans from private banks. And, you know, an attorney might be able to defend those lawsuits and raise some defenses, you know, in court that could help keep them from collecting and help keep them from prevailing in those lawsuits. So if you are served with a lawsuit from one of those trusts, I would encourage you to, or anybody just generally, to call legal aid, to call a private attorney to discuss your options. Another one of these companies that sues where a lender might have defenses against them is Student Loan Solutions. I think they tried to buy a lot of loans from Bank of America, and the issue is they didn't always keep the paperwork to show that they made that transaction, or that, you know, those loans actually transferred hands. So that would be the defense that an attorney might be able to make in court if someone is sued by that company. So, you know, that's I'll just wrap up there. I know it's a lot of information. I'm getting a little hoarse, but you know, I just wanted to try to give everybody a roadmap of what was out there, so that, you know, if you think one of these things apply to you, if you're not sure, if you have a question, that you know that you could reach out to legal aid. If you qualify for our services, reach out to an attorney and explore that a little bit more. So that's it. Thank you.
Okay, so I just wanted to hop on again and let everyone know. We do have an intake form on our website if you would like to go and sign up at don'tshootpdx.org. Fill out the intake form, and then we can get you connected with someone from Legal Aid of Oregon to help you out. Or you can use any of the links in the chat. Please make those resources available, because we've got a ton of links in here. So this video will also be uploaded onto YouTube, so you can view this later, and we'll have the link up on our main website and our newsletter and Facebook. So thank you all so much. Any questions you can drop in the chat before everyone logs off. But yeah, I think we've got 20 more minutes unless we end early.
Also let people know those 3 dots on the side can be saved in the chat.
Oh, cool. You can also save the chat by heading to the chat, clicking the 3 dots next to file, and you can actually save as a note under your computer. So please save the chat so that you can have access to all of these resources later on. And for people that are using the phone, our dialed in callers, we will make these resources available as well. We're going to save the chat and upload it with the video so that it's accompanied with the chat. So thank you all so much. I think that's it. Okay.
Yeah, thank y'all. It's nice to see like so many people show up for the training. So thanks everyone for showing up.
Yeah, thank you.
Thanks.
Oh, is anyone available to expand on the extra $600? That's a question from the chat.
Yeah, I think I talked about that. So the extra $600, the technical name for that is the Pandemic Emergency Unemployment Compensation. And this is an additional $600 benefit that comes out of the federal assistance. And you don't have to submit a separate application for that benefit. You'll be considered for it when you submit an application for regular unemployment, or when you submit an application for the Pandemic Unemployment Assistance, which is the unemployment for people who are gig workers, independent contractors who don't have the work history to qualify, anybody who doesn't qualify for regular UI and is out of work due to COVID-19. So when you submit either one of those applications, you're considered for the extra $600. And you're supposed to receive that. I don't think there are, other eligibility things that you need to meet. You should just receive that as a separate check if you're eligible for the main benefit.
So if you, let's say you apply for unemployment, but you are rejected, would you not be eligible? Would you still qualify for the extra $600 just because you applied, or no?
No, I don't think so, because it piggybacks off the main unemployment benefit.
Thank you. I think those are all the questions that we have in the chat.
Oh, somebody did ask, I'll just mention it because I saw it now. They sent me a message privately if I could expand on the extra federal unemployment compensation. So that, I think, is the federal pandemic unemployment compensation. And that's just a fancy word for the extra 13 weeks that you can get of regular unemployment. So regular unemployment usually lasts just 26 weeks. So if you were already getting unemployment and you're at the end of your 26 weeks, you should get a notice from the employment department, hey, your time's almost up. You need to apply for this extension. And they should be directing you. I think the application's available on their website, but they should be directing you to apply for that benefit just so you could get a 13-week extension of your regular unemployment. And that, people, if they're eligible for it, can get it going into July 25th of this year.
Okay, thank you. Let me continue scrolling through the chat just to make sure. It looks like there's a follow-up to the extra 600. They're asking, do you have the conditions to qualifying for the extra $600? Things like, do you have to not miss the check-in every week? Do you know if you need to be in compliance with all of that in order to qualify for the extra payment?
Yeah, you need to submit that recertification every week, reapply for every week after your initial application for either regular unemployment or PUA. And so you don't need to submit an extra application for that $600. You should be considered with it along with your application for regular unemployment or PUA, pandemic unemployment assistance. But you do need to keep, recertifying every week, reapplying every week to continue to get that $600 and the underlying benefit.
Okay, I think everyone is good. Oh, okay, I have an update. What if I missed retestifying because you were unaware of the date?
So so I could say generally, like if you have a question about if that happened to you, if something happened to you and you want to call the public benefits hotline, we can hopefully look into your particular situation and see if there's advice that would help you. But I think it's really important to remember to file that weekly application and to do it on time. So I think, let me see. You need to, so if your application for the previous week is due the next week before midnight on Saturday, right? So if I needed to submit my application for this week that we're in right now, I would need to make sure that I got that form filed and into the employment department before 12, like the end of the day Saturday. So like before the clock strikes midnight Saturday of next week.
All right. I don't think we have anything left in the chat. Thank you everyone so much for joining us. Thank you to the lawyers, the interpreters, and of course our viewers and supporters. Like I said, I'm going to upload these resources with the videos so that if anyone needs these, they will be available. So again, thank you so much, and just keep a lookout at don'tshootpdx.org for more of these webinars we'll be having. And yeah, thank you everyone so much. Have a good day.